Hello, everybody. Bill Prince here. Welcome to our discussion of torts, which is contained in Chapter 12 of your textbook. Hopefully, torts will be a little shorter lecture than our previous two, dealing with contracts and contract breach and damages. When we talk about torts, we're not talking about a French cream pastry, which I think maybe are tarts, but a tort is a civil wrong not arising from a breach of contract or other agreement, and it's a breach of a legal duty that proximately causes another person a harm or injury. So we're not talking about contract law in this particular case. We're talking about the breach of some other kind of legal duty that may exist between people. For example, if I am driving down a street, I owe a duty to other drivers on that street to operate my motor vehicle in a prudent and cautious manner. If I get liquored up and drive while intoxicated, if I'm not paying attention and am texting or talking on my phone rather than paying attention to traffic conditions and injure somebody, I may well have committed a tort because, again, I owe a legal duty to people to operate my motor vehicle in a consistent and safe manner, and my failure to do that caused others potential harm or injuries. When we talk about torts, much like when we talk about contracts, we're talking about civil, not criminal wrongs. And if you recall, when we talked about the difference between civil law and criminal law, in criminal law, we're talking about a situation where the state is the victim and where the individual being charged with a crime can suffer a risk of loss of their life, their liberty, or their property. When we talk about civil law, we're talking about generally circumstances that arise between private entities, and generally in torts, we look at paying damages to compensate the individual who is injured. There's a number of different torts. We're going to talk about a few of them. There's what's known as business torts, and again, as you go through the textbook, you'll see examples of these spelled out as well as the notes. But business torts occur when an individual or business interferes with another's business's rights. And we see sometimes that we have interference with contracts. We see that we have slander and things of that nature. So pay a little bit of attention to that discussion in your textbook. There's also what are known as intentional torts, and intentional torts are where there is a wrongful act committed knowingly and with the intent to commit that act. So if somebody intentionally, for example, operates a motor vehicle in a reckless way down the road, that well could be an intentional tort, and many times intentional torts come pretty close to being criminal in their nature. Then there are what are known as unintentional torts, and those are acts that are committed without knowledge of its wrongfulness or without the intent to commit the act. So there again, if I'm driving my motor vehicle down the road and I'm acting in a negligent manner, it may well not be my intent to harm somebody, but because I was fiddling around with my phone as opposed to looking out my window and I rammed somebody, I am going to be liable whether I intended to commit that act or not. The general purpose of tort law is to compensate or make whole those people who suffer legally recognizable injuries. If no injury occurs, no tort exists, and there's nothing to compensate. So many times when we talk about torts, there has to be an actual damage to somebody. Somebody has to show some sort of emotional harm. Somebody needs to show some kind of physical harm. Again, the law generally doesn't reward people who have not been injured in some way or another. When we talk about tort law, the tort usually recognizes two types of damages generally. There's compensatory damages, and you might remember that term from our discussion on contracts. Compensatory damages are those damages that are designed to reimburse the plaintiff for the actual value of his injury or loss. So again, if I crash into somebody because I'm being negligent in operating my motor vehicle, I've probably caused property damage to that individual's vehicle, so I would be responsible for repairing the car or replacing replacing it if the damage was that severe. The individual may well have suffered some physical injuries, whiplash, broken bones, cuts, bruises, lacerations, things of that nature. And I could well be responsible for paying for the medical bill, physical therapy, and things of that nature thereafter. Additionally, the individual may have lost time at work because of that, and so those may be fair game damages as well. And then there's punitive damages, and again, sort of as we talked about in the contract context, punitive damages don't necessarily bear any sort of relationship to the amount of injury that the individual suffered. Rather, punitive damages are awarded to send a message, not only to that business or individual, but to also others, that this kind of conduct is not appropriate, and if you engage in this kind of conduct in the future, you could potentially be looking at these kind of damages. So, a number of years ago, there was a case where I think it was General Motors designed a pickup truck, and on that pickup truck it had what were called saddlebag gas tanks, which basically there were two gas tanks, and they were kind of under the passenger side and under the driver's side. And it came to pass that as a truck driven by a young man entered an intersection, he was T-boned, and it caused the truck to burst into flames, and this young man was unfortunately killed. And of course, a lawsuit was filed, and in the course of that lawsuit, it was determined that General Motors, in fact, knew that this was a design defect, that by putting these tanks in the location where they were put, that this kind of thing could happen, and yet they still produced the product in that way, figuring it was cheaper rather than to go back and retool the thing. So needless to say, when that information came out, a huge punitive damage award was issued against General Motors. At that time, I think the largest in the history of the court system, to punish them for that conduct. Because businesses in particular are looking at potential, ruinous amounts of damages in some cases, or because businesses are sort of, getting the old death by 1,000 cuts, where they're constantly getting sued for everything they do. There has been a real move afoot, and particularly with a number of Republican Congresses and state houses, these moves have taken hold and have gained some ground, but there's this idea to try to limit the ability of people to come in and sue businesses, and because again, that is expensive. They're potentially at large risk. Even if the lawsuit is frivolous, it costs money to defend. So there's been a big push by business to try to lead this push called Tort Reform. And again, it's because they believe that the current system of things like contingent fee agreements and that sort of thing cause all these frivolous lawsuits. You've seen all the commercials on television. Have you been hurt by this, that, or the other thing? Call me. It's not going to cost you a dime. You only pay us if you recover, that kind of thing. And so in response to that, business has tried to get a hold of the state houses and pass tort reform. And so there's an example here, the Class Act Fairness Act of 2005, where large class action lawsuits were shifted from state courts to federal courts to avoid what was called forum shopping. In some of these cases where people are injured by a product that a lot of people use, plaintiffs' attorneys would go and try to file in states that were most favorable to plaintiffs, and federal court tends to avoid that kind of thing, and so this act protected that. And then, as you can see, that many states have capped non-economic damages; those are the punitive damages, in a lot of these kinds of cases, to try to again sort of prevent the incentive for these lawsuits occurring. In our discussion question this week, you'll have an opportunity to look at this issue in a lot more detail. Yikes, that slide got tiny. One of the big or common kinds of torts, and again, in the notes you can see there's a whole bunch of them, but I just wanted to highlight a couple of them in this lecture, is negligence. And negligence is failing to exercise the standard of care that a reasonable person would exercise in similar circumstances. So again, let's go back to my situation where I'm operating a motor vehicle, driving, say, south on Glenstone towards the battlefield Brownfield Mall, and I am texting on my phone and not paying any attention to where I'm going, and the light changes, a car in front of me stops, and I slam into that car, causing the car to be damaged and the driver to be injured. For there to be negligence, the plaintiff, or the person who is claiming to have been hurt, has to prove all of these factors. That the person who did the injuring owed the plaintiff a duty of care. Again, that's pretty clear in a case like this, that when you operate a motor vehicle, you operate that motor vehicle, you owe a duty of care to other drivers and pedestrians about to operate that in a safe manner. What about this question, though? And again, this is kind of a weird example, but let's say that you're driving down Glenstone, and you same thing. You're looking at your phone. You crash into the car in front of you. That causes a hubcap to fly off the car in front of you, and that hubcap then hits a bicyclist that's driving down the street and knocks the bicyclist off his bike and causes the bicycle to fly into a store window where it injures a customer in that store. Does the customer in that store have the right to sue the person who was driving their car and not paying attention to the road? That's where it gets a little more problematic. The second thing is that the tortfeasor or the defendant has to breach that duty. So again, if I am driving down the road, not paying attention to the road, looking at my phone and crash, I have breached my duty to operate my motor vehicle safely. Thirdly, I have to actually injure the plaintiff, or actually causing the plaintiff a legally recognizable injury. So again, there I've damaged his car or her car, I've caused personal injuries, and so in that case we would have an actionable case of negligence. All right. There's a couple of concepts that you need to know about negligence as well, and that's contributory negligence and comparative negligence. Historically, we used to have contributory negligence be this sort of the general rule. So here's how contributory negligence worked, and why we don't see it as much anymore. Let's say, for example, that a UPS driver, we'll just say, was having a bad day, and stopped in for lunch at a place where alcohol was served, got drunk as a skunk, and then started driving his UPS vehicle while he was in an intoxicated condition, and during the course of that crashed into me. Say the guy was going 100 miles an hour on Glenstone, just terribly reckless, crashed into me, totaling my car and causing me catastrophic injuries. You'd say, well, that's a clear case that UPS is going to be responsible for my damages. Well, under contributory negligence, let's say that I didn't have my seatbelt on, that I had failed to click it. And in that case, the argument could be made that, well, I contributed in some small way perhaps to my injuries by not having my seatbelt on, and if you could show any kind of contributory negligence, that would be enough to defeat the entire claim, and so the UPS driver would get off scot-free. That's pretty harsh, and so we've seen contributory negligence sort of morph into what's called comparative negligence, and in that situation where both parties may be negligent to some degree or another, we balance those two things. So, for example, if in the situation involving the UPS driver, the damages were $1 million, the jury might look at it and say, well, UPS was 95% responsible for that, negligent, and Prince was 5%. So, in a case like that, I would not be, out everything. I would get $1 million less 5% of my negligence. So that's a bit fairer when you think about that. There's a few defenses to negligence, and a couple of those we talked about, contributory and comparative. There's also assumption of the risk, and so a plaintiff who voluntarily enters a risky situation generally will not be allowed to recover if something bad happens, and that includes knowledge of the risk and voluntary assumption of the risk. So what if I am becoming have a bucket list and I want to bungee jump off the San Francisco Golden Gate Bridge, and so I hire a bungee jumping company and they have me sign releases and all this stuff saying that, bungee jumping off this bridge is dangerous. It can cause, damage and death and all that sort of thing. And I sign it and I jump and I get killed or I get seriously injured. Would I be able to sue that bungee jumping company? And again, the answer is it depends, like the answer in a lot of legal situation is. But again, assuming that they weren't negligent in any way, assuming that they set the rig up and that kind of thing, and I just, something happened and I died, probably they're not going to be responsible because I assumed that risk. On the other hand, if they somehow failed to take care of that issue or they, rigged me up incorrectly or something like that, probably a different story. Okay, well, that's a brief discussion of torts, and we will visit with you again on our next chapter, which I think is strict liability. So have a great day, and we'll talk to you then.